Good afternoon, Judge Hoffman. Can you hear us?
Yeah, I can. I can. Can you guys hear me?
We
Yes,
can.
sir.
All right, Tony, are you ready? Tony, are you there? Oh, she's still connecting to audio.
I have with me Sayuri Shimoda, who's my uh, co-worker here at my law firm.
Great,
She's an 8-year lawyer, is that right? Yeah.
great, awesome. All right, let's go on the record on cause number DC 22-15312, Wilkins v. La Frontera Holdings. Uh, Tony, you ready?
I'm ready, Judge.
All right, you may proceed.
Your Honor, I'm Walt Herring. I'm here on behalf of the defendant, La Frontera, and with me is Sayuri Shimoda.
Could you spell her name just so we have it for the record?
Sayurishimodo.
DA.
DA, sorry.
Okay, Mr. Eddington.
Your Honor, Michael Eddington, Busby Law Firm, on behalf of the plaintiff, Keith Wilkins.
All right, we're here on a motion for summary judgment, correct?
Partial summary judgment. Yes, Your Honor.
You may proceed.
So a quick background for us again. I've just to refresh your memory, Judge. I know you have a lot of cases. The plaintiff in this case, Mr. Wilkins, is not my client's employee. He is hired by and was supervised by and under the direction of his employer, PTW. PTW was a contractor at my client's power plant out in Midland, Odessa. We are related to Vistra, the power company. We operate that power plant for them.
And Mr. Herring, just so you know, I remember this case and I've read all the briefings. So
Okay, well, great. Then maybe I'll just move on then. So we're here. The issue arose when we've been trying to we discovered in discovery a while back that there was a workers' comp claim or somehow was involved in this. And so in our interrogatories and requests for production, we asked for those documents. We are so told they would be supplemented and they never were. Well, they were eventually. We asked for that in discovery, in written discovery, and then when we deposed Mr. Wilkins, he claimed he had no knowledge of the status of his claim, etc. Finally, in the summer of 2024, a year or so after we started these inquiries, I started asking, "What are you going to supplement? Are you going to supplement?" The workers' comp records were finally supplemented at the very end of October, literally days before we had filed a motion to compel hearing for them. Days before the motion to compel hearing, we got partial records. And in those partial records was the final decision of the Workers' Comp Board, which talked about a pre-injury MRI, which is very important to our case, the right knee, talked about some expert reports that weren't noticed of. And so we asked for those documents and we pushed forward with the motion to compel. But in that, what was produced was the final decision in the workers' comp hearing. And that led to this, once that was discovered, we hadn't seen it before, that led to this motion for partial summary judgment because we believe the right knee issue has now been collaterally estopped through the workers' comp proceedings. And that's the subject of our motion today.
so I read the briefing and let me make sure I kind of understand the argument that you're making. So I guess in the workers' comp appeal process, they made a determination that the knee injury was not related to this accident. Is that right?
That is correct. It was specifically, and we can pull up the slide if you want. I have a slideshow. Can you share screen with me, Your Honor?
Yeah, you could go ahead and share screen.
Oop, hold on.
Yeah.
If you want your co-counsel to help you with that, that's okay.
Exactly. She's much more efficient at this than I am.
Okay.
Okay, can you see that? That's our slide there, the initial slide. And so the elements of collateral estoppel are the facts need to be litigated in the second action, that's ours. were the same.
Can you go to the second slide? Because I think you're on the first slide. It just says the front.
Oh, okay. That's not what's showing on ours.
I see that all I see is the first slide.
That one. How about maybe we should run the show? Is the show not running?
It's showing.
Well, we have my second slide on this
Mr.
thing.
Eddington, do you see the first or second slide?
Just the first slide, Your Honor.
Yeah, I'm not sure.
I'm not sure either. Should we play the slideshow
There we go.
from the beginning? Yeah. Okay, so the elements of collateral estoppel. You're seeing the side screen too, I guess, but that's fine. So the facts sought to be litigated in the second action, our action, were fully and fairly litigated in the first action. Those facts were essential to the judgment in the first action, and the parties were cast as adversaries in the first action. Now, that last one's been modified. This is the Supreme Court's collateral estoppel. The last one's been modified by the Supreme Court in Cisco Food Services, that the only person necessary is that the party against whom the doctrine is asserted was a party. And so our contention is these three elements are clearly met on this right knee surgery. That were clearly discussed and at issue in the workers' comp hearing. Go to the next one. So our decision here that we got, this is the decision that was produced at the end of October. And the statement of the case in that decision specifically says that Judge Hector Martinez held a hearing on August 9th, 2023, more than a year before this was produced, to decide the following. Does the compensable injury of April 5th, 2022, that's the injury in this case, extend to and include the right knee anterior crucial ligament, the right knee medial mental tear, the right knee lateral meniscus tear, the right cracked femur, the right knee internal, basically his entire right knee issue was directly at issue in this lawsuit. And this next thing that was at issue is, did he have a disability from this injury from April 15th of 2022 through the date of the hearing as a result of this injury on April 5th, the injury we're talking about? They specifically made in that statement, in that findings of fact. The finding of fact specifically said that this compensable injury, this right knee injury, was not a producing cause of a right knee, of those issues with his right knee, was not a producing cause. The second thing they found that's related to our lawsuit is the compensable injury was not a cause of the claimant's inability to obtain and retain employment at wages equivalent to his pre-injury wage. So lost wages and his right knee are both clearly at issue here. And then in the conclusions of law, the judge found that the compensable injury not related to his right knee issue, and he did not lose money from it. That injury was not a result of his disability and lost wages. So the first issue, was this cause fully and fairly litigated? Now, plaintiffs say it wasn't, but people were present. The claimant was there. Mr. Wilkins testified at the hearing. They had 37 exhibits introduced at the hearing. They had several hundred pages of exhibits at the hearing. They had expert opinions. Dr. Brown appeared and talked about how the claimant, some of this was related to it, possibly. And then they had an expert from the PTW, from the carrier, who said, no, this is all pre-existing. All of these things are pre-existing. So the issue was clearly at issue here, and they had their ability to do that. Now, the plaintiff in their response has said, oh, well, they didn't talk about Dr. Amkar, and I'm sorry, Michael, if I'm mispronouncing his name. Is it Davi or Dave? How do you pronounce Dr. Dave's name?
Could you spell that?
Dave. Omkar, Amkar Davi, Dave. And the plaintiff's response to this motion, they say, well, they didn't talk about Amkar Davi, so collateral estoppel can't be applicable here. Well, that's not the issue. The issue is it's fairly litigated. Dr. Davi did his surgery, the total right knee replacement, 5 to 6 months before this hearing. Before this hearing. The lawyer who represented Mr. Wilkins in this hearing clearly had access, or could have had access, to Dr. Davi. They could have made those arguments. They didn't. So if this was allowed to happen, why would collateral estoppel would never apply? Because Mr. Eddington, I'm not pointing at Mr. Eddington in general, but the next counsel could just say, well, we were going to have another expert come in and say it. We didn't like what Dr. Brown had to say. We wanted to have Dr. Davi come in and talk. But they had that opportunity. It was fully and fairly litigated at that time because there was an expert there for the plaintiff, for Mr. For Mr. Wilkins, and there was an expert there for the carrier. And then the facts that were numbered, so it was fully and fairly litigated. Don't know how it could have been any more fully and fairly litigated than it was. And the case law we're going to look at all says if there's findings of fact and conclusions of law, and they had their opportunity to pitch their case, that's fully and fairly litigation. We can't go back and second guess. The next element, the facts were essential to the judgment. Well, again, those facts were clearly essential to the judgment because as we just looked at, the statement of the case was they held a hearing to determine those two things. There's no question that the facts were essential to that judgment. And the plaintiff was the adversary. He is here now. He had his opportunity to make this case that this injury is a result of the accident on April 5th of 2022. He had his opportunity here. And that's all that the Supreme Court requires. He had the opportunity. He was present and did it. My client didn't need to be there. Now, if my client wasn't there, it wouldn't be collateral estoppel because we're the ones who would be trying to say, hey, we get to make another argument. But from the Supreme Court's perspective and from Texas case law's perspective, this is clearly collateral estoppel. Now, there are a couple of cases I would like to talk about. Catch me up on my outline. I got ahead of myself. Sorry. The first case, you say, well, has this ever been in the case law? It has. This estate of Howard.
I was interested in that case, actually. So was the decision in that case based on a ruling in the Workers' Comp Commission or a district court ruling? Looks
It
like
was a workers' comp ruling that ruled that the plaintiff, at that time, it was a common law wife, claiming a common law wife, asking for the death benefits under the workers' comp death benefits. This fellow died. And they held a hearing on whether to determine whether she was indeed a widow, a common law wife of the defendant, of the plaintiff, the deceased. And they determined that she was not. She then went and filed in district court a wrongful death claim and tried to relitigate that issue, that she's the common law wife. And in that case, she also added two other defendants. He was working for a contractor. I think they entered the property owner. It didn't really describe who the other defendants were, but there were three defendants in that case. One of the defendants moved for just this thing, collateral estoppel, saying this has been litigated. She's not the common law wife. And the appeals court upheld that. The trial court said, you're right. This issue has been litigated. You're not the common law wife. You can't bring a wrongful death.
Can you share screen that decision so I can take a look at the case?
Sure.
Should be.
How do I get that bigger?
The actual opinion, not this PowerPoint.
Oh, yeah. Can I send it to you, Your Honor?
You could. You don't have it up on.
Well, I do have it up. Let me see if I can get to that.
You would just have to stop sharing this and share that instead.
Yeah. Siri's going to work on that. And I don't want, we'll get it up here before the end of the hearing, Your Honor.
Okay. I mean, I will tell you that my main question about this really relates to this case. So it would be helpful to see it.
Well, look, can I talk briefly about some other ones while she's going to pull it up?
Sure, you'd like to.
So the other one we cite in our case is against the carrier lost on this one, and that was a infection case. The guy cut his finger. It infected, got a bacterial infection in his heart. In 1978, they determined that indeed that bacterial infection was caused by that worker's injury, and the company had to pay his medical expenses. But they also agreed that it would cause him in the future, and they entered into this settlement agreement that they would pay it in the future. Well, 15 years later, they hadn't paid. The worker sued him in district court saying, you owe me my back money for this because I've had to deal with this now for 15 years. It wasn't a huge case. I think it was like 15,000 bucks. Wasn't a whole lot of money, but you owe this to me. And they said, oh, no, we get to litigate that again. And the district court in that case said, no, Mr. Carrier, you don't get to litigate that again. It's been decided that his infection was because of this cut on his finger, and these expenses are related to that. And so, sorry, buddy, but you've got to pay. So it cuts both ways. That the adversary in that one lost, the carrier lost that one. All right, we're back to the share screen. Hold on. Trying to get to my.
Yeah, here.
Shall we share screen?
Yep.
Okay. There it is.
Okay, let me take a look at it.
Sure. Well, you want to scroll down to?
Yeah, keep scrolling, please.
I'll be happy to send this to you too, Your Honor.
So just so you kind of know what I've already kind of decided what I'm going to do, which is I'm going to probably take this under advisement because I do want to have a chance to look at this case. I think this case is really critical, and also, shepherdize it, see what Dallas Court of Appeals has done with this issue. So,
Great. Why don't we do that? And honestly, I expected the court to do just that. We have you ordered a mediation. We're mediating Wednesday afternoon. So,
Okay.
but I want this issue to be out there. So I will send this to you, and I'll send a copy to Mr. Eddington too, just so you'll
Well,
have.
let me say exactly what I want if the case doesn't settle in mediation on Wednesday, is I'd like a binder with both sides briefing on it, with these two cases as well highlighted. I'll probably shepherdize or have an intern shepherdize it. Make sure, especially this particular case, which I think is critical. And then, Mr. Eddington, I don't remember any real cases that you cited too. This one seemed to be the most on point, but
Your Honor,
really,
I would like to make one point about the case he cited.
okay,
This is the Barnes case.
okay,
And they cite the Barnes case as a case that held the opposite, that didn't allow the workers' comp ruling to go forward in the district court. But they read that case incorrectly. I want to make sure I make this point. The
okay,
Barnes case was a heart attack case. They called the incident at work caused the plaintiff to have a heart attack. That is a heightened burden. There's a specific different statute in the workers' comp that it's not just preponderance of the evidence. It's got to be, it's the heightened burden of proof on a heart attack case because it can be congenital and all those sorts of things. So it's a much higher burden of proof. When they brought this issue up at the district court denied the carrier's position that this decision had been decided because it was a different burden of proof. In the district court's preponderance of the evidence, and at the workers' comp hearing, it was a heightened burden. So they said the plaintiff, the worker, had a heightened burden in that. That's not the same burden, so it doesn't apply. And in dicta, the Barnes court said if this was just a negligence and or gross negligence case, that the preponderance of the evidence, this would be collateral estoppel. It would be collateral estoppel if it was just a negligence and gross negligence case. But because it's a heart attack case, and it's a heightened burden under the workers' comp in heart attack cases, it doesn't apply here. So we didn't put that in ours, in our initial briefing, Your Honor, because honestly, we didn't want to cloud the issue because it was irrelevant, because it was just dicta that supports our case. But it does not support the plaintiff's position that it wasn't collateral estoppel and you can't use this for collateral estoppel. It wasn't used because it's a different burden in that hearing than in this.
We'll include that case as well. So the notebook one, I wanted to include all of the briefing. You can wait until after the mediation to submit it, just because I know you don't want to waste time. But if the case doesn't settle in mediation, then I want a binder with both sides briefing all of the cases. I didn't remember the Barnes case because I thought this was the most important one, but the Barnes case as well. And if there's any other cases involving workers' comp
These are the three we found.
okay. If there's anything else you find or anything, but include any relevant cases in the binder as well, and get that to me by Friday if you don't settle the mediation.
We will do that, Your Honor. And one other thing about I'm just going to mention this because it's not set for hearing today, but because we just found out about this collateral estoppel a month ago, we have filed a motion to amend our pleading to assert that as a affirmative defense. We had no idea it was there until then, so we believe there's good cause for that, and we have filed a motion for that because the pleading deadline was in January of 2024, 11 months ago.
All right, I'll definitely take a look at that. I think you guys are set for trial coming up pretty quickly, right?
January 14th.
Let me just see where you guys are on the docket. I would imagine you're number one, but let me see. Nope, you're number two. So
Who's ahead of us?
there's another 22 case. Oh, that was just reactivated. So I'm not sure why it was reactivated, but
I was just curious.
yeah, I can give you the cause number. It's DC 228250. The plaintiff's attorney is Kevin Giddens. I don't know him. Out of Tyler, his number is 903-526-9000.
Okay.
And the defense attorney, which is confusing what's going on. Oh, looks like it's Cass Caramita, so I'm sure you know.
Yep.
Anyway.
Okay. Thank you.
Okay, so let me hear argument from Mr. Eddington.
Your Honor, getting to speak. Your Honor, most of our argument is based on the statute itself. I think we're gonna address this when we submit the briefing on it. But our argument is that it was not fully and fairly litigated. I think you can tell by just the sheer number of pages that were attached to the ALJ decision. He says that my client had doctors there. If you look at what doctors testified in the ALJ decision, it was 3 comp doctors, a designated doctor per comp, a peer review doctor, and an required medical examination doctor. It was not Omkar Dave, who's been doing the bulk of his treatment, who did the knee surgery, who has over 450 pages in this case, whereas there were only 163 pages of documents produced in total in the workers' comp case. So as there's a requirement that the issue be fully and fairly litigated, we do not think that requirement is met in this case. And in addition to Omkar Dave, there's 15 other medical providers who we've designated as experts in this case will testify at trial. And we think based on that first element. Another issue we addressed in our motion, which I think the defendants have conceded, is although this was submitted as a partial motion for summary judgment, their order said this disposes of all claims against the defendant and is appealable and final. So we had to address the other injuries because it seemed like they submitted an order to this court disposing of the whole case, but I think in their reply brief they admitted, no, this is just a partial motion for summary judgment. It's not getting rid of the whole case. It doesn't deal with these other injuries. So I don't think we need to go much further than that into those injuries.
All right, anything else?
Well, I might briefly respond, Your Honor. I know you hate this sort of thing, but the 450 pages, they are repetitive as repetitive can be. If you actually went and looked at took out the duplicate pages, it'd be less than 100, I think, honestly. It's confusing with this for if they're just doing the document dump, but they're repetitive pages. And as far as the uh, uh, I want to make clear too, because they put this in their response, where they said that the court had denied the prior summary judgment motions. I may have missed it, Your Honor, but I did not hear denial of those summary judgment motions. And I've gone back and I've looked at the uh, docket sheet because I make mistakes and there's no order there. But when we left, the court did what I thought it would do, honestly, is say, I'm going to take these under advisement. You guys need to go get this mediated. And that's what we're doing. But I have not received a ruling on the prior motion for summary judgments on duty, causation, liability, and damages. And as far as the experts are concerned, we're going to have an issue at that at trial too about what these designated experts can talk about.
If I can brief new issues that the defendant brought up.
Sure.
I had made that comment in my response because this court had made a comment in open court, which I'm sure this court knows, that it never grants motions for summary judgment on medical causation like they were requesting in this case. So that's why I put that in that motion. I'm sure this court is well aware of how it how it operates its court. So.
All right, guys. Well, thank you so much. Just good luck with mediation. Who are you mediating with?
The only date Mike Metcalf had available.
Oh, good. Mike's.
Yeah.
Have you mediated with him before?
I have, Your Honor, and he's a good mediator.
Yep.
Literally, after you ordered it, I called him within a week. The only day between now and the end of February he had available was December 11th in the afternoon.
Wow, interesting. Okay.
All right. Thank you,
Good
Your
luck
Honor.
with that, and just remember to get me the binder by Friday if it doesn't settle. Okay.
Fair enough. Thank you, Your Honor. Have a good day.
Thank you, guys. You have a great rest of your day. Rhonda, did Kathleen leave?
Mhm. She only has it from, I think it's 2:30 to 4:30, something like that.
It's not even 4:30 yet. Is she there?
Or maybe it's 2 to 4. No, she just left. It could be 2 to 4. Let me look at that thing. Hold on.
Okay.
I'm sorry, Judge. It's 2 to 4. And she just left.
Okay. I wanted to talk to her because was she there with you or?
She was in your office, and so it wouldn't be doing that noise and stuff.
Okay, because it's like she wasn't even like on the screen the whole time because Tony told me how she was doing makeup the other time. And now this time she was like, I don't know, I couldn't even see her the whole time. And so can you just teach her how to like sit so that she's in the screen so it doesn't look like
Yes.
she's sleeping during the thing?
I'm
Anyway,
sorry about that, Judge.
that's not your fault. It's just anyway. All right. Well, I will. So Tony, it looks like we do. Well, let me see if anything's changed. We do, I think, still have. Do we still have the DCADs left? Let me see.
Yeah, they're still on there. I'm gonna give her a call now and see what she has. If
I
not,
think
then we'll be scrambling in the morning.
so. We have. It does look like the Discover Bank case is actually contested. There's attorneys on both sides, so that looks like it'll be an
Okay.
actual trial. Um, but and who knows with DCAD? So we have one Discover Bank case left and 3 DCADs. So still no jury trials. Let's see what's going to
Yay.
happen. No, not today.
Oh, no, yay, no, bad.
Oh no, Rhonda, no.
Don't worry, we'll have some next year. Hopefully.
I
Okay.
know. I'll make up for it.
Okay.
We do have some really big ones set next year. The Tuvalu case and this
Yeah.
Wall case. Those could both be multi-week trials. So let's see what happens. But
I'll
anyway,
be glad to
guys,
get rid of them though.
what?
I'll be glad to get rid of them though, because they think we have somebody
They have so many hearings. It's just like, oh my
Yeah.
gosh, let's get this thing
Mhm.
done. All right. I will see you guys.